Welcome to Legal Baatchit, where we interpret legal frameworks and provide clarity. In this session, we are focusing on Section 12 of the Insolvency and Bankruptcy Code, 2016, a crucial aspect of corporate fiscal health in Indian jurisprudence. The Insolvency and Bankruptcy Code revolution is corporate insolvency in India by streamlining and expediting the process. But why does it matter? Effective insolvency resolution in the corporate world renews opportunities for businesses and creditors, not just closes chapters. Today, we'll examine Section 12 of the IBC, which controls the insolvency resolution clock. Section 12 sets the pace for the insolvency resolution timeline, and stakeholders must be aware of it every day. Let's examine Section 12's significance, application, and impact on corporate insolvency resolution. The financial ecosystem relies on insolvency proceedings to rescue distressed companies. They aim to orderly, fairly, and equitably restructure a company's debts. Finding a solution that balances creditors, debtors, shareholders, and employees' interests is key. Time-bound insolvency resolutions are crucial. Business relies on time as much as capital. Prolonged insolvency proceedings can rapidly devalue the debtor's assets, reducing creditors' options and reducing a company's revival. Quick resolutions preserve value, give creditors certainty, and allow viable businesses to quickly re-enter the economy or efficiently reallocate resources to more productive uses. Insolvency and Bankruptcy Code Section 12 applies. The insolvency resolution process is timed by it. Section 12 limits insolvency resolution time to prevent it from dragging on. This time-bound approach minimizes financial and operational uncertainty to maximize insolvency outcomes. In the following sections, we'll discuss Section 12's timelines, their rationale, and the consequences of not following them. Understanding Section 12 is crucial because it dictates the resolution deadline and affects all stakeholders' strategic decisions during the insolvency process. Explaining Section 12. Insolvency resolution timing revolves around Section 12 of the Insolvency and Bankruptcy Code, 2016. Analyze its effects on corporate insolvency resolution. Rule 12. 1. The corporate insolvency resolution process shall be completed within a period of 180 days from the date of admission of the application to initiate such process. After application acceptance, insolvency resolution must be completed within 180 days. 180 days, why? The law wants a quick resolution to protect the insolvent entity's value and let creditors redeploy their capital. This deadline helps commercial ecosystem confidence because uncertainty hurts everyone. Article 12. 2. The resolution professional shall file an application to the adjudicating authority to extend the period of the corporate insolvency resolution process beyond 180 days, if instructed to do so by a resolution passed at a meeting of the Committee of Creditors by a vote of 66% of the voting shares. Here, flexibility is provided. If the Creditors Committee with 66% voting shares agrees, the resolution professional can request more time from the adjudicating authority. Although quick resolution is preferred, complex cases may take longer to resolve. Section 12(3) discusses the adjudicating authorities on receipt of an application under subsection 2. If the adjudicating authority is satisfied that the subject matter of the case is such that corporate insolvency resolution process cannot be completed within 180 days, it may by order extend the duration of such process beyond 180 days by such further period as it thinks fit, but not exceeding 90 days. Upon reviewing the resolution professional's application, the adjudicating authority may extend the process by 90 days. Single-use benefits with checks and balances are not free. The authority must be convinced the case's complexity warrants extra time. While speed is important, the Insolvency and Bankruptcy Code emphasizes quality and sustainability. The complexity of Section 12 shows this. We will discuss how these provisions have been applied and interpreted in real-world scenarios and their implications for stakeholders in the following segments. Amendments and updates. Section 12 of the Insolvency and Bankruptcy Code has been significantly amended, affecting insolvency resolution. Changes to Section 12. The code allowed a 90-day extension on the 180-day insolvency resolution deadline. The legislature capped the resolution timeline due to case complexity and legal delays. The amended insolvency resolution process, including Section 12 extensions and legal proceedings, must be completed within 330 days of commencement. This amendment clarifies the timeline for timely resolution. 330-day timeline implications. This updated timeline requires the entire insolvency resolution process, including judicial processes, to be completed within 330 days, regardless of complexity. This has major consequences. 1. The resolution professionals and Committee of Creditors must work efficiently and decisively to meet the tight deadline. 2. Adjudicating authorities must prioritize cases to prevent delays. By clarifying the maximum resolution or liquidation time frame, corporate debtors and creditors can improve planning and decision-making. Legislative intent. These strict deadlines have multiple purposes. Improve business ease. Fast insolvency resolution is essential for a positive business climate and foreign investment. Valuation maximization recognizes the rapid decline of distressed asset values over time. Quicker resolutions increase creditors' recovery rates. Certainty in outcome. Fixed timelines enable creditors and investors to make informed decisions. Quick asset redistribution, redistributing assets from unprofitable businesses to productive sectors. These amendments demonstrate India's dedication to a disciplined, time-bound resolution framework that follows global best practices. We'll discuss how these timelines are implemented and their effects on the resolution process in the following sections. Judicial interpretations. The judiciary plays a pivotal role in interpreting the statutes laid down by the legislature. Through various judgments, the courts have provided clarity on the application and nuances of Section 12 of the Insolvency and Bankruptcy Code. Let's examine some key judicial decisions that have influenced the interpretation of this section. Case law interpretations. 1. Quantum Limited versus Indus Finance Corporation Limited. The National Company Law Appellate Tribunal, NCLAT, in this matter clarified that an application for extension of the insolvency resolution process can be filed even after the expiry of the initial 180 days. This judgment provided relief to resolution professionals and committees of creditors who might face unforeseen delays. 2. Sky Blue Papers Private Limited. The National Company Law Tribunal, NCLT, stressed that a mere passage of time is not sufficient. There must be substantial grounds for granting an extension beyond the stipulated timeline under Section 12. This reinforced the need for a justified rationale behind any delay in the resolution process. 3. Quinn Logistics India Private Limited versus Macsoft Tech Private Limited and Oz. The NCLAT held that in certain unforeseen circumstances which are beyond the control of the stakeholders involved, the period for counting the resolution process duration may be excluded. This decision allowed for a more pragmatic approach to the calculation of the 330-day limit. 4. RBL Bank Limited versus MBL Infrastructure Limited. The NCLT ruled that if the adjudicating authority is convinced that it is in the interest of justice, the time limit for the insolvency resolution process can be extended. This underscores the court's discretion in matters where the strict application of timelines may lead to unjust outcomes. Analysis of judicial decisions. These judgments underscore a few critical themes. 1. Flexibility within framework. Courts have recognized that while the timelines are strict, a degree of flexibility is necessary to accommodate complex cases and unforeseen challenges. 2. Necessity for justification. Any extension beyond the prescribed limits requires substantial justification, ensuring that delays are not merely due to procedural lags but are warranted by the circumstances of the case. 3. Justice as the guiding principle. Ultimately, the aim is to achieve a just and equitable resolution of insolvency matters, even if that requires extending the process beyond the stipulated timeframe. 4. Pragmatism in application. The courts have adopted a practical approach, acknowledging that certain delays, particularly those due to legal proceedings, are sometimes unavoidable and should be accounted for in the resolution timeline. These interpretations have had a profound impact on the conduct of insolvency proceedings, ensuring that while the process remains time-bound, it is not at the expense of fairness and justice. In the next segment, we will explore the real-world implications of these judicial interpretations for stakeholders involved in the insolvency process. Impact assessment. Section 12 of the Insolvency and Bankruptcy Code greatly affects insolvency resolution. It's not just a law, it drives stakeholder behavior. Let's examine how this section affects insolvency parties. Implications for insolvency resolution. Quicker decision-making. All parties must act and decide quickly on the 180-day timeline, with a possible 330-day extension. This has made insolvency resolution faster and less procrastinatory. Section 12 enforces strict discipline, requiring resolution professionals to move quickly during proceedings and negotiations between creditors and debtors. Resource optimization. Fixed timelines reduce asset limbo, potentially increasing creditor value distribution. Impact on creditors. Certainty and predictability. A clear timeline provides creditors with predictability in the recovery process. Financial planning and risk management require this. Enhanced recovery rates. Faster resolution can increase recovery rates by preserving the value of distressed assets. Strategic decision-making. Creditors should prioritize strategic decision-making during committee meetings due to time constraints. Impact on corporate debtors. Quick resolution. Corporate debtors can exit insolvency faster through revival plans or liquidation, enabling a fresh start or orderly closure. Asset preservation. Prompt resolutions support businesses with restructuring and turnaround potential by preventing asset value erosion. Pressure to cooperate. Tight deadlines require distressed company management to collaborate with resolution professionals and creditors to expedite resolution plans. The impact on insolvency practitioners. Enhanced accountability. Resolution professionals must meet deadlines, ensuring efficient resolution processes. The insolvency process is time-sensitive, requiring professionals to act decisively and manage it with agility and precision. Operational challenges. Insolvency professionals must handle tight deadlines, complex negotiations, and legal hurdles efficiently. Challenges and criticisms. Section 12 of the Insolvency and Bankruptcy Code, 2016, adds time-bound elements to the insolvency resolution process, but it has critics. Let's examine some of the issues and criticisms surrounding these timelines. Problems following timelines. 1. Insolvency cases can be complex due to complex financial structures, multiple stakeholders, and legal issues. In cases requiring thorough due diligence, meeting deadlines can be difficult. 2. Legal proceedings. Insolvency proceedings often involve legal disputes and court proceedings. Resolution professionals may not be able to control these delays. 3. Negotiations. Reaching a resolution plan with creditors can be a lengthy process. Finding common ground among stakeholders is difficult, especially within deadlines. 4. Operational issues. Managing daily operations of a distressed company during resolution can be challenging. Maintaining business viability or asset preservation is a delicate balance. Feasibility criticisms. 1. Critics argue that strict timelines may not account for the complexities of complex insolvency proceedings as they may be suitable for simple cases. Rigidity may lead to hasty or suboptimal resolutions. 2. Judicial overload. Insolvency courts often face heavy caseloads. Critics say the judiciary's insolvency case processing can delay deadlines. 3. Some argue that strict timelines may favor creditors over debtors, as the pressure to resolve quickly may prioritize creditor interests over debtors' ability to recover or restructure. 4. Impact on value. Rushing resolutions may lead to suboptimal results. The strict timeline may hinder this process when distressed assets can be maximized through careful deliberation and negotiations. These challenges and criticisms must be balanced against the need for a timely and efficient resolution process. Stakeholders, legislators, and judges struggle to balance quick resolution and thorough due diligence. Comparative analysis. To truly appreciate the significance of Section 12 of the Insolvency and Bankruptcy Code, let's place it in a global context by comparing its timelines with insolvency timeframes in other jurisdictions and discussing global best practices. Comparative analysis. United States, Chapter 11. 1. In the US, Chapter 11 bankruptcy proceedings do not prescribe fixed timelines for the resolution process. 2. Instead, the debtor typically continues to operate the business as a debtor in possession, while formulating a plan to restructure and repay creditors. 3. The flexibility of Chapter 11 allows for a more tailored approach to the resolution of complex cases. United Kingdom, administration. 1. In the UK, administration procedures generally aim for a quick resolution within a year, but there is no specific statutory time limit. 2. However, administrators are required to work promptly and efficiently to maximize returns for creditors. Australia, voluntary administration. 1. In Australia, voluntary administration typically lasts around 25 to 30 business days, but it can be extended if needed. 2. The emphasis is on a relatively quick assessment and decision-making process. Comparison with Section 12. 1. Section 12 of the Insolvency and Bankruptcy Code, with its prescribed timelines and strict caps, represents a unique approach. It enforces a more expedited resolution process compared to some other jurisdictions. 2. While this approach has its advantages in terms of efficiency and value preservation, it also presents challenges, especially in complex cases where a more flexible timeline may be required. 3. Section 12's rigid timeframes are designed to balance the need for speed with the necessity of ensuring fairness and preserving value. Global best practices. 1. Global best practices in insolvency resolutions emphasize a balance between efficiency and flexibility. 2. An ideal insolvency framework should provide guidelines and goals for timely resolution without sacrificing the quality of the process. 3. It should also encourage collaboration and negotiation among stakeholders, ensuring that the best possible outcome is achieved within a reasonable time frame. Conclusion. In the journey through Section 12 of the Insolvency and Bankruptcy Code, we've uncovered a critical cog in the machinery of insolvency resolution in India. This section, with its prescribed timelines and provisions, is not just a legal text, it's a powerful force shaping the corporate landscape. At its core, Section 12 embodies the essence of timeliness in insolvency proceedings. It sets the clock ticking, reminding us that in the world of distressed entities, every day counts. It's a reminder of the old adage that time is money, and in the context of insolvency, it's often the difference between revival and demise. The importance of timely resolution. Timely resolution in insolvency proceedings is crucial for several reasons. 1. Value preservation. Swift resolutions help preserve the value of distressed assets. As time passes, assets may deteriorate, making it harder to satisfy creditors' claims. 2. Certainty and confidence. Timely resolutions provide certainty to creditors, investors, and the business community. This predictability encourages investment and bolsters confidence in the commercial ecosystem. 3. Economic efficiency. Efficient resolutions ensure that resources tied up in unviable businesses are quickly reallocated to more productive uses, promoting overall economic efficiency. 4. Crisis management. Timely resolutions are essential for crisis management. They prevent businesses from lingering in insolvency, helping them either recover or gracefully exit the market. Section 12 of the IBC reinforces these principles by setting strict timelines and allowing for controlled flexibility. While it has faced its share of challenges and criticisms, it plays an indispensable role in the insolvency resolution process. As we wrap up our discussion on Section 12, let's remember that it's not just about legal provisions, it's about the real-world impact on businesses, creditors, insolvency professionals, and the broader economy. It's a reminder that in insolvency, time is the essence, and every moment matters. Thank you for joining us on this exploration of Section 12. Stay tuned for more legal insights on Legal Baatchit.